Please be seated. Veuillez vous asseoir.
Good afternoon. Good afternoon to everybody in and outside the courtroom. I give now the floor to the Republic of South Africa, if they wish so, for a reply. I don't know if you want to take advantage of this or not. You have the floor. The
Microphone.
Apologies. Mr. President, honorable judges, yes, indeed, South Africa would wish to make use of this opportunity to make a few further statements in reply. Thank you. I'll hand to Professor Clary that would do that on behalf of our country. Thank you.
Professor Tladi, please, yours the floor.
Thank you very much, Mr. President. Let me just preface my remarks by saying that we have limited our rebuttal only to new issues that arise, and so we will not respond to many of the issues that were raised by the Office of the Prosecutor with which we do not agree, but which do not raise new issues. And also, given the short space of time, our response will be fairly brief and not as comprehensive as it would be if we had 2 days to respond. So I will raise 7 issues. The first issue is that counsel for the Office of the Prosecutor has suggested that South Africa's position concerning the law has been evolving over time. I would like to be clear. South Africa has not submitted any legal arguments to the court until 17 March 2017, when it filed its submissions with respect to this hearing. It further submitted arguments this morning. These are the only arguments that reflect South Africa's position with respect to its duty under the Rome Statute. We recall that in our submissions this morning, we emphasize that we are not concerned here with domestic law, that we are concerned with international law and our international obligations. Arguments made by South Africa in domestic courts concerned domestic law and domestic obligations in terms of that law and not international law. They do not affect at all our international obligations and are not reflective of the position with respect to our duties under the Rome Statute. This much is clear from the 2009 statement by the former Director General of the Department of Foreign Affairs, which set out that South Africa is under a duty to arrest Mr. Al-Bashir. It stated, and I quote, "If today President Bashir landed in the country in terms of," and I emphasize, "the provisions of," I shall read it again slower. Thank you, sir. If today President Bashir landed in the country in terms of, and I emphasize, the provisions of our law, he would have to be arrested, unquote. It is only in this context that we have accepted the duty to arrest. The second issue, in the oral submission, the Office of the Prosecutor suggested that South Africa submitted to the court that the International Criminal Court, this chamber, has no authority to interpret UN Security Council resolutions. But of course it does. And in fact, we said so this morning, that it must. The problem that we expressed this morning was that the court didn't interpret. Our statement, to which we think the Office of the Prosecutor refers, can be found at paragraph 92 of our submission. And there what we say is that the court cannot be seen to be the sole arbiter in terms of the interpretation of the UN Security Council resolution, not that it may not interpret the UN Security Council resolution. Our argument, in fact, is that while the court may interpret the UN Security Council resolution, it does not have the special powers of interpretation that it has with respect to the Rome Statute. proceed now to the third issue. Counsel for the Office of the Prosecutor argued that the decisions by the UN Security Council to decline the AU's request for deferral is an indication that Council believes Mr. Al-Bashir does not have immunity. With respect, that simply does not follow. Article 16 request for deferral is not based on Mr. Al-Bashir's immunity, but rather on peace and security and the peace versus justice issue. That's what it is based on, not on immunity. So we can draw no conclusion from the UN Security Council's decision to decline the AU request with respect to immunity. Fourth issue. Counsel for the Office of the Prosecutor made reference to operative paragraph 6 and suggested that this showed an intention by the UN Security Council to waive immunity. I won't repeat the arguments that we made this morning concerning the true effect of operative paragraph 6, since that would not be part of a rebuttal. I would only state that operative paragraph 6 has nothing to do with immunities. On its terms, if you look at the language that is used in operative paragraph 6, it applies to persons with immunity and it applies to persons without immunity. So that cannot tell us anything about immunity. The Office of the Prosecutor suggested, much like the decision in Malawi and Chad, that the interpretation that we offer on Article 98 would, and I quote, emasculate the ICC, render it useless, futile. Again, this does not follow. This argument suggests that the ICC is only about officials of non-state parties. It is not. In fact, the ICC is not only about the prosecution of persons with immunity. The large majority of persons before the ICC, of accused persons before the ICC, are persons without immunity. Moreover, there are a host of avenues through which a person such as, or a head of a non-state party, such as Mr. Al-Bashir, could be brought before the ICC. Waiver is one. Of course, that is difficult to accept, but it is an avenue. Another avenue is when such a person is no longer a head of state. Another option, and really the most important option, is if the UN Security Council decides to impose an obligation on all states, then of course there would be a duty to arrest. Finally, the cases we are talking about here really only arise in exceptional circumstances. That is, in those cases where the situation at hand has been referred by the UN Security Council. There have only been 2 of these cases. For the most cases, heads of state can be arrested, should be arrested, because they would be heads of states of they would be heads of state of states parties. So it is therefore a gross exaggeration to suggest that this interpretation that we have offered would emasculate the ICC. Sixth point. Sudan is not, as is suggested by the Office of the Prosecutor, comparable to a state party. It does not have the right to decide or to vote in ASP. It does not pay membership fees. The only thing that Article 13b of the Rome Statute does, or rather a UN Security Council pursuant to Article 13b does, is to confer jurisdiction on the court. That is the only thing. And yes, it is also to ensure that the whole statute applies. But the whole statute, as we said, includes also Article 98. But it does nothing more than this. Indeed, this is clear from operative paragraph 2 of UN Security Council resolution. UN Security Council resolution operative paragraph 2 places an obligation on Sudan. This would not be necessary if Sudan was in a position comparable to that of a state, because then part 9 of the statute would already apply and there would already be a duty on Sudan to comply, or rather to cooperate. My final point in rebuttal. The Office of the Prosecutor referred us to PP1. PP1 is preambular paragraph 1 of Resolution 1593, which notes the report of the International Commission of Inquiry. Now, Council suggested that because the Commission referred to the fact that most crimes were committed by governments, that in fact this reference in PP1 is an indication that Council sought to waive immunities. But like most other arguments that we have heard today, it simply does not follow. All that it means, if we were to accept that line of reasoning, is that Council knew that immunities might be a factor, and it still decided not to address them, thereby leaving the general rules of international law to be applicable. Mr. President, Your Honors, we have completed our rebuttal. I would only like to once again thank you for your attention and for this opportunity to engage on these very important issues. We remain hopeful that the Chamber will consider our arguments made this morning and during rebuttal this afternoon. We also take this opportunity to confirm that South Africa remains committed to the pursuit of international criminal justice and the pursuit of a peaceful world and a peaceful Africa. Advocate De Wet.
Thank you very much, Madam De Wet.
Thank you, President, honorable judges. That concludes then the submission that South Africa wanted to bring to the court today. Thank you.
Thank you very much. This, I would say, concludes today's hearing on this issue, scheduled within the Article 70, Paragraph 7 procedure of the Article 87.7 of the Rome Statute procedure. I would like to thank both parties for their submissions. We will, for sure, and we can assure you, I can assure you on behalf of the Chamber, that we will duly consider them. Judge Jung asked me to put some questions on background information to the delegation of South Africa before concluding. So please, Judge Jung.
Thank you very much. And I also appreciate both parties for providing such valuable arguments on these very much difficult and important issues in a very efficient and effective manner. So I'd like to ask some questions to the Republic of South Africa, especially on some background information of request for consultation. It would be appreciated if you could provide some further information regarding this issue. According to Para 36 of your submission, the second sentence, which was also quoted by prosecution this morning, you stated that the request to the registry was made when it became a real possibility that the president of Sudan would indeed attend the AU summit. So would you elaborate on what happened what happened in South Africa government between 28 May and 12 June regarding the decision-making process of request for consultation, if available.
Mr. President, honourable judges, thank you for those questions. Of course, we have indicated that in our submissions that we are not going to rehash what happened with Article 97 consultations, but we welcome the question and we want to address that. South Africa has been tasked or requested to host the AU summit on a very short notice. You will understand, honourable judges, that in a government system such as South Africa, the wheels can turn very slowly. So this decision has been taken in January that South Africa would host the AU summit in June. That triggered a very big rollout of activities for the government to get ready for that occasion. Of course, one of the issues that we had to determine and to deal with was indeed the conclusion of the host agreement. As Professor Clary indicated this morning, this is the standard practice for South Africa, and we do host, similar to Belgium, very often international meetings. So, of course, you would specifically ask what happened in between a specific period of May, end of May, and then at the beginning or 12th June, when we actually made the request for consultation. What happened was that the AU invited heads of government and state to come and attend the AU summit. Because South Africa was hosting that, we did not fully have a control over who will attend and who will not attend. We were dependent on receiving information in this regard. Many of the heads of state, long before the meeting, would have confirmed the firm confirmation, provided firm confirmation that their heads of state will indeed attend. This was not the case in Sudan, and we want to be very clear, and we want also to disperse with the innuendo that South Africa waited until the very last moment to approach the court. That is simply not true. We are not an individual. This is a country. Its machinery turns very slowly. Indeed, the matter of the attendance of President Bashir was discussed. Indeed, it was a worry for South Africa. But this is how government works. We received the confirmation of the attendance of President Bashir. In fact, after officially he landed in South Africa, officially we were informed after the fact. When it was clear, and remember, South Africa also invited President Bashir was also going to attend other functions in South Africa at previous years, and there was always a situation where his attendance was avoided. This was now a different situation where we had the AU summit to be hosted in South Africa. AU invited. The indication that he would come was then on the table, off the table. South Africa did not know until the very last moment that this is a reality. This does not mean that we were not worried about what will happen. We were aware that there will be a problem. We just didn't want to jump the gun. And the government, in that sense, in hindsight, it would have perhaps been better to be prepared and to have a legal team ready to come here at, say, the Thursday rather than the Friday. Government wheels turn slowly. So that is what we want to place before the court. We came to the court with good faith. We came to the court in an attempt to try and resolve a situation that we find ourselves in. Of course, our cabinet were informed of this. There is no doubt about that. Of course, we want to place on record that we as a government did all that we can to come to the court in good faith and to trigger a system, a 97 request for consultations that have never been done, and that there are no procedures that guide that process. In that is where we found ourselves at the eve of of that 12th June, the Friday evening, and that is where the events unfolded as being placed before the court that happened in our national court. Thank you, judges.
Thank you very much. Just one more question to Republic of South Africa. So, and paragraph 40 in your submission, you also state that the ambassador to the Netherlands was not mandated to represent the government in the consultations. So, may I ask what made you take this kind of position? The ambassador was not in the position to represent the government at that time, and someone from the capital was supposed to represent the government. On what grounds did you make this kind of decision?
Thank you, honourable judges, for that question. Our ambassador was tasked with one mandate. The mandate was to approach the court to request for consultations. I want to say again, there is no rules and regulations or guidelines that govern how Article 97 consultations should be approached. We thought to start off with this process, we would send our ambassador, together with a note verbal, to request the court to enter into consultations. The idea was that the legal team would come to the Netherlands, that will come once that consultations are scheduled to come and represent the government's case. That was a simple matter of fact. Our ambassador is our political head here. The arguments that we would have wanted to place before the court in a consultation, once we have discovered or once we have been informed of how this would be arranged, would have been not of such a nature that we would have felt that the ambassador should be burdened to promote those arguments in the consultation. So that was a practical reason why the government at that stage only mandated the ambassador to make the request. Thank you.
Thank you very much. That's it from me.
Thank you. Now, once again, this concludes now the hearing of today in this matter. The Chamber obviously will issue its decision in due course. I cannot now foresee what due course or specify better what due course means, but I think I can give two general indications. The first is that we will for sure come out with a decision before the summer recess of the court, and the second is that we will issue the decision in a public hearing and not just with an anonymous filing. So this are the two indications I can give, and of course the parties will be, and all the public will be notified of this well in advance in order to be prepared to attend the hearing when the decision is issued. Thank you very much. The hearing is closed now and adjourned to whenever we are ready. Thank you very much.
All rise.